think everybody knows me, but just in case, I'm Rich Mills from Ship on Goodwin, and I'm here with my colleague Jessica Ritter, and it's great to be here tonight to talk about two issues, really, the FOI statute we have in Connecticut, and also the second topic will be board roles and responsibilities and administration roles and responsibilities, probably with some overlap across the two to some degree. But we'll start with the FOI statute, and we're going to keep this very informal and interactive, so please jump in. We'll go through the PowerPoint, which you've got in front of you, but please jump in with questions or comments or disagreements or whatever, you name it. We're happy to talk it through. So again, we'll start with the FOI statute, and Jessica and I are going to alternate every few slides, and we'll do it that way. But again, jump in as you have questions. As you can see, we're going to focus first on the FOI statute, and one of the things I like to do about the FOI statute when we talk about it is to try to boil it down to its simplest parts. Basically, Connecticut's FOI statute is Connecticut's commitment to open government. FOI statutes, or open meetings or open records laws, really came into existence after Watergate. They're all post-Watergate. Just about every state, or probably every single state, has an FOI type statute, as does now the federal government as well in the post-Watergate era. And post-Watergate was quite a while ago, so this statute has been around really since 1975. It's really addressing two things in Connecticut, but the overarching principle is access to government. And basically, it addresses two things. One, meetings of public agencies, and secondly, records that are developed or maintained by public agencies. And in either case, whether we're talking about a meetings issue or a records issue, the primary focus of FOI is to make meetings accessible to the public and records accessible to the public. That is the fundamental purpose of the FOI statute. Now that doesn't mean that every single aspect of every meeting and every single record is open to disclosure. We'll talk about that as we go through. But whenever you look at an FOI issue, and whenever we as lawyers, counsel to the board, this board, or any board, whenever we get an issue that's an FOI issue, we always ask the question, how does this relate to the purpose of the statute, and how will the FOI Commission, which is the commission in Connecticut, charged with the responsibility of administering and enforcing this statute, how would they look at this issue if it came up? And simply put, it's not what's convenient or what's best, it's what does this statute actually require in terms of access to meetings and access to records. So we'll break this down and move through this and go through each piece of this. So we first start out with who does the law apply to? It applies to any public agency or agency in Connecticut. And what that means, and all these words, there's a lot of words up there, but basically any executive, administrative, or legislative office of the state or any political subdivision. And you'll notice, and that certainly includes, every town in Connecticut, every school board in Connecticut for sure, every zoning commission, wetlands commission, every commission you can think of that you might have within a particular town or even the state government itself. And you'll notice that we bolded and italicized one piece of this because I want to just emphasize this. That is that it also applies not only to the whole board or the whole town or town council, whatever the case may be, but committees thereof. So if the Torrington Board of Education has 5 committees, let's say, on whatever topics, policy, negotiations, grievances, whatever, the FOI statute applies to any committee that you establish. So, and sometimes boards aren't as, I'm sure I talk about this board when I say this, sometimes boards are not as aware of that as they are that the full board has to be subject to the statute. But every committee that you create or exists within Torrington, every committee is subject to the provisions of the FOI statute. So again, if you have a policy committee meeting, that meeting, and we'll go through what has to happen every time you have to have a meeting, that meeting is just as subject to the FOI statute as your regular board meetings. There's no difference. Functionally, there's no difference between a committee and a full board. So that's a very important point, because every time you have a committee meeting, agendas, minutes, motions, the whole 9 yards, all of that applies when you're talking about committees under the FOI statute. So that's what covers the FOI statute. Sure.
Would that only be committees that are in the board guidelines as standing committees?
No, because if, for example, suppose you had an ad hoc committee, you decided to create a committee on school security in the wake of the Newtown tragedy. That committee would be subject to the FOI statutes.
So they would have to.
Now there are administrative committees. There's an exemption in the FOI statute, and we'll get to this, for administrative committees. For example, obviously we can't post every meeting that goes on in the high school in the course of a day. There may be curriculum committees, there may be evaluation committees, there may be all sorts of staff committees. Here in the central office, there may be committees of the superintendent. Most of those are not going to be subject to the FOI statute because you couldn't function that way. Your faculty meetings obviously are not, they're not meetings within the meaning of the FOI statute. But if the Torrington Board of Education creates a committee or a task force, sometimes, and task forces would be subject to this as well. You have a curriculum task force, and you invite people in the community to be part of that. It might include some board members, it might include some members of the administration. That would be subject to the FOI statute. Again, if you go back to the purpose of the statute, the purpose of this statute is to create access to government, and you are a government. I know you may not like that, you're part of the governmental process, and the whole purpose is to make it accessible and hold it out in public view. So that's, you always have to go back to that. Even when we look at the definition, if there's a gray area, you can be sure that the FOI Commission is going to interpret that definition expansively. And so if a question is this committee subject to the statute, you can be sure that that case goes before the FOI Commission. They're going to look at that very expansively. And I'm not suggesting it shouldn't. I mean, that's their job, is to enforce that law the best they know how, subject to court appeals if there's been a wrong decision. But basically, you can be sure they're going to look at it very expansively.
So what about if you created like a principal search committee and these people were going to...
Actually, I'm going to come to that. I'm going to cover that in just a minute because there is an exemption for personnel search committees.
Okay.
There are some committees, very limited numbers, that end up essentially not being part of the statute. So, but basically, the presumption should be that if it's a committee, it's part of it. It's governed by the statute. So what is a meeting? Now this, and you'd think it's interesting because obviously the FOI statute was written by lawyers, and we lawyers can sometimes make things a little complicated, I will admit. And you would think that the term meeting would be a fairly straightforward thing. A meeting's pretty straightforward as to whether something is going on as a meeting or not. But it ends up being a fairly complicated kind of thing. The FOI statute defines meeting to be any hearing or other proceeding of a public agency. And I'm going to go back through this because all these words on this one especially are important. Any convening or assembly of a quorum of a multi-member public agency. And any communication by or to a quorum of a multi-member public agency. And then it goes on to say whether in person or by means of electronic equipment to discuss or act upon a matter over which the public agency has supervision, control, jurisdiction, or advisory power. Now that's a lot of words, so I want to go back through that because this one's really important. The hearing, clearly we know what that is. If the board's going to have an expulsion hearing, that is a meeting. It's got to be posted as a meeting under the FOI statute. That's very clear. If that's run by a board subcommittee, not the full board, but a committee, again, covered by the FOI statute because we talked about committees. Or other proceeding. That's a very broad term. Basically, anytime the Torrington Board of Ed gets together, and again, there'll be some exceptions that I'll come to, that's going to be deemed to be a proceeding of a public agency. Then it goes on to say, any convening or assembly of a quorum of a multi-member public agency. And I'm going to go on to the next part because I want to link these two together. And any communication by or to a quorum of a multi-member public agency. The bottom line is this. If you have any kind of interactive communication of any sort, in person, by phone, text message, email, chatting, Skyping, you name it, telephone conversation, anything you can think of. If there is interactive communication going on among members that constitute a quorum of either the full board or a committee of the board, about matters within that board or that committee's jurisdiction, that is a meeting. So just, I'm going to talk totally hypothetically here. So suppose we have 9-member board, right? Or actually, is it 9? 10. Okay. So a quorum would be 6. You deem 6 as your quorum? Okay. So if 6 members of the board, clearly if 6 members of the board are in a room having a conversation about a matter within the board's jurisdiction, and they're talking about that matter, that's a meeting. Again, there'll be some exceptions that I'll come to in a minute, but That's a meeting. If those 6 members aren't all together in person, but they're doing some kind of Skype or chatting or emailing back and forth to get to weigh in on a proposed policy. Suppose the superintendent has a proposed amendment to the student discipline policy, and she's floated that out to the board members. And again, I'm going to talk totally hypothetically here. 6 board members or some quorum begin to talk about that proposed policy in email or whatever form they wish to, or at the grocery store or whatever. If that constitutes a quorum of the board, and they're talking about that matter of public business, that is a meeting, and it probably wasn't posted, so it's an illegal meeting under the FOI statute. The FOI Commission has ruled that even if you add up a series of conversations, so I talked to Ken talks to Jessica, I'm presuming we're all members of the board here, Jessica talks to Cheryl, and sooner or later, we end up with a quorum. The FOI Commission will look at that and say, you essentially are circumventing the FOI statute by having a series of conversations that add up to a quorum of the board. And the whole, again, if you go back to the purpose of the statute, because take my example of the amendments to the student discipline policy, that's a matter of legitimate public interest, clearly, and that's a matter of public concern. And the public is allowed to watch that happen. They're allowed to watch that, they have a right by statute to watch that dialogue occur. And if it's occurring somewhere else that isn't accessible to the members of the public, they've been denied the right of access. So it's critical that you realize that any kind of, and it's really the interactive communication. Let me distinguish something else. Suppose the superintendent wants to have the board members come to the board meeting having had a chance to look at the proposed policy. Makes sense, it's efficient. So she sends out a memo to all the board members and says, here's I've attached the recommended policy that the policy committee developed. The board will discuss and act upon this, or at least have the first reading of it next Tuesday night. And she sends that out in an email to all board members. Let me ask you a question. Is that email from the superintendent to the board members, standing alone, does that constitute a meeting? No, because there's no interactive communication. That's a one-way piece of communication. Same thing, if the board chair sends out a memo saying, here's amendments to the proposed bylaws that we're going to take up next Tuesday night at the board meeting. Please don't comment back to me, but please read these things so that when we get to the board meeting, everyone has had a chance to develop their thoughts. That one-way communication is perfectly fine. Happens all the time, and it's perfectly legal. Now, that communication will be FOIable, and that's the second part, which is the records part. That's an FOIable communication, but it isn't a meeting. Now, suppose, again, hypothetically, because this wouldn't happen, of course, suppose board members start, even though the superintendent said in her email, please don't respond, we'll talk about this at the board meeting on Tuesday, but a bunch of board members begin to have dialogue back and forth, and everyone's commenting on those emails, and it's basically a big conversation. That's a meeting. That's a problem. Because, again, that's not a noticed meeting, and there's the public's business is essentially going on in the email exchange, which the public doesn't have a right to see as it's going on. They will have a right to those emails, because, again, those emails are public, but that's not the answer. The answer is they're being denied access to a meeting of the Board of Education. So, and Jess will cover this when she gets to her part, and I'm probably jumping ahead here a little bit, but you have to be very careful about things like, especially with technology. Texting, it doesn't matter how it's done. It does not matter. Phone conversation, texting, email, chatting, Skyping, you name it. That adds up to interactive communication for a quorum, you have an issue. Again, take it back to our committee. Suppose it's just the policy committee, and I'm just going to make a number. Suppose the policy committee has 3 members, and 2 of those members of that committee begin having a dialogue about, the superintendent sends that out to the policy committee and says, I'd like you to read this in preparation for the policy committee meeting next Tuesday. Fine, no problem. If those 2 members, now we're down to 2 members because 2 is now a quorum. If those 2 members start having dialogue about that outside the meeting, that's a problem. That's an FOI violation. So you've got to be careful.
I'm positive you've probably been asked this question before. What distinguishes the executive committee of the Board of Education as the 3 of them gathering to establish with the superintendent on a monthly basis, or however often they get together as a group to set agenda and possibly discuss whatever whatever they want to discuss, but how is that exempt from?
The executive committee itself is subject, it's a committee of the, if it's firmly established and formally established as a committee of the board, then it is a committee of the board. Now, there is an exemption in the FOI statute for, with very limited terminology, that allows you to determine, for example, whether board members can come to board meetings on certain dates, for example. But the framing of the agenda itself would be something that would need to be, that's a committee meeting, subject to the FOI statute.
So if they're going to on the first Monday of every month, the 3 executive board members are to meet with the superintendent to set the agenda for next week's board meeting. Is that something that needs to be posted, and is it allowable, or is the press allowed to be there? And is other board members, if it's not an FOI so-called meeting, then if other board members were to attend that, i.e. Monday night, 7 other board members show up, do we now have a full board meeting that's FOI?
Great question. You have to be careful with that. If the FOI statute contains a provision that says, if suppose the policy committee is meeting, that's 3 members, and the other 6 board members decide, well, it's a meeting, I want to go see what the policy committee is talking about, they have the rights as citizens to go to that meeting. And the FOI statute is specific in saying that that will not constitute a board meeting. That's a policy committee meeting in that example. It's not a board meeting just because you happen to have those other members there, because they have a right as citizens of Torrington to go to that board meeting. It's a public meeting, to go to that committee meeting, I should say. However, one big caveat to that is, if the purpose is to circumvent, and I'm not suggesting this would be the case here at all, so again, I'm talking totally hypothetically, the FOI commission would look at that to be sure that the purpose of that was not to circumvent the FOI statute. In other words, that the purpose isn't to have a board meeting, but call it a policy committee meeting. If the underlying purpose truly is to have a policy committee meeting, and it so happens that members of the board happen to be there, that is okay, that is fine. But you have to be careful and treat it as a policy committee meeting. For example, the non-committee members are really members of the public for the purposes of that meeting. They're not members of the committee, and they shouldn't be treated as members of the committee. They're like observers in the public, just as any other member of the public would be treated.
But then want to answer my original question, which is?
Yes, the executive committee meeting would be posted. Now, many boards have the board chair meet with the superintendent to frame the agenda. That is not a committee at all.
Okay.
That can be done informally.
That's how we do it.
That is typically how that is done in any school district, is that the board chair meets with the superintendent, and they're allowed to frame the agenda. That's not a committee, it's not deemed to be a committee, and you'd be allowed to frame the agenda it's not a posted meeting, so the FOI statute would not apply to that at all.
But if the 3 were to get together?
If the members of that committee get together, that's a meeting of the executive committee.
And if they said, the standard practice is always chairman meets Monday night with the superintendent, but by chance, next Monday night, the other 2 executive members.
Well, again, you have to be careful. I mean, the FOI commission will look at things, they will look not only at the label you put on something, but they'll look at what's really happening. And again, when I say that, I don't say that about Torrington, I say that just generally. They will get behind the issue to figure out, is this really some sort of attempt to have a meeting that's not being posted? They will get behind the facts to figure out what's really happening. And again, that's why, for example, my example before about the series of phone calls, the FOI commission will look at that and say, look, if it's clear that what you were doing here is having what they call a seriatim meeting, a series of conversations, adding up to a quorum, they're going to get that.
So just one more
Sure.
follow-up, which is, so every Thursday, I'm only talking hypothetically, I don't know what.
I understand.
But hypothetically, every Thursday, the chairman calls each of the board members and says, it's my time to ask you, what would you like to see on the agenda? And every board member tells them, like, talk to the lawyer, talk to the superintendent, whatever it is to put on the agenda. You have all 9 talking on Thursday to this chairman, and now the chairman on Monday goes and regurgitates back.
I would say that the better practice on that would be perhaps at the end of each board meeting to say, and some boards do this, if there are suggested or requested agenda items for the future meeting, next meeting, whatever, please either say them now or get them to the superintendent. Again, you want to minimize the board member interactive dialogue when you're talking about those kinds of issues, because then you're going to run into a problem.
Okay, thank you.
Sure. So that's the basic definition of meeting, and as you can see, again, that's it looks like a simple thing, but the term meeting can turn out to be a very complicated kind of thing. So here are some of the exemptions. The meeting does not include, and these are things that are essentially carve-outs under the FOI statute. The first is, and this is the question that got asked earlier, any meeting of a personnel search committee for executive level employment candidates. So if you're doing a search for a high-level, executive level position, that would certainly include superintendent, assistant superintendent, principals. If there were questions about other positions, we should talk about it, but let's just take those as the basis. If you are conducting a search for any of those positions, executive level positions, then the FOI statute allows the board to form what's called a personnel search committee, and you want to label it as such. And then meetings of that personnel search committee are totally exempt from the FOI statute. Now, an important distinction. Boards frequently in Connecticut appoint the members of the board as the personnel search committee. For example, it's a search for a superintendent. It's common in Connecticut, and the FOI Commission has upheld this practice, that you can actually appoint each member of the board together, comprising the personnel search committee. You're allowed to do that. The function of that committee, however, is not to appoint, use the example superintendent or principal, is not to appoint, because that personnel search committee by statute can only recommend to the Board of Education. That has to be their authority. That's the limit. So take my example where the board appoints itself as the personnel search committee for a principalship, some principalship in Torrington. The board can do that, and there are no other members of the committee, just the members of the board. Every personnel search committee meeting would not have to be posted. It's exempt as long as it's meeting for that purpose. It would be exempt from the FOI statute. However, when the work of that committee is done, that committee can't hire anybody. That committee has to recommend to the board. You might say, well, that's sort of a fiction because we're the same people. So be it. The bottom line is you're acting as the committee when you're conducting the search. It's the board that makes the appointment. And so at the time you go to make the appointment or get the recommendation of the personnel search committee to the board, that would have to be a posted meeting of the Board of Education. But that personnel search committee is the first exemption. The second exemption is, and this one makes sense if you think about it, any chance meeting or a social meeting, neither planned nor intended for the purpose of discussing matters related to official business. So, if it's the holidays and you're all at somebody's house for a holiday party, or one of you has a holiday party and you're all there, or you're all at the same wedding, or you all end up at the same shopping store on a Saturday, that is okay. You don't have to go running out of the store or the wedding or the Christmas party or the holiday party or what have you. You don't have to do that. You're allowed to stay, but you can't talk about board business. If you begin to talk about board business, that's going to be deemed to be a board meeting. And it makes sense, because obviously you'd have to be allowed to go about your lives. You may all end up on the same Little League field or baseball field someday, just because you're there to watch a game or something, or you're at a neighbor's party. You have to be able to have your lives. But you can't then take advantage of that moment to conduct board business or committee business. Again, watch that committee versus board distinction too. So you want to be careful about that. But you are allowed to have social gatherings that are purely social or be at the same place without running out the door. The third one is strategy or negotiations with respect to collective bargaining. So this allows you, for any bargaining unit, and this is only union situations. This is not negotiations of the bus contract. That's not a union, that's not a collective bargaining situation. We get this question periodically. Well, aren't negotiations exempt? No, collective bargaining negotiations are strategy or negotiating sessions. So, if the board's going to talk about preparation for the teacher negotiations, what do we want our proposals to be? Or the board's going to have negotiations with the teachers, sit down with the teachers' bargaining unit and have contract negotiations. None of that has to be posted at all. Negotiations and strategy related to those negotiations are all totally exempt from the FOI statute. So it doesn't have to be posted at all. Obviously, you have to make sure, let's assume you have, we use the term non-meeting. Only lawyers can dream that out. But that's what we call it. So if you're going to have a collective bargaining non-meeting, strategy session and a non-meeting, you can do that. But obviously what you can't do is use that non-meeting to talk about other matters. You've got to limit yourself to collective bargaining. So you want to be careful about that. The next one is a caucus of members of a single political party. Notwithstanding that such members also constitute a quorum of the public agency. So you are allowed to have, and some boards do this, not all do, but some boards do, you're allowed to have a political party caucus within a Board of Education or a town council or a Board of Finance or any other public agency in Connecticut. You can have caucuses. And those caucuses are not subject to the meeting requirements under the FOI statute. The last one is what I talked about before, an administrative or staff meeting of a single member public agency. So that basically is, and then communication limited to notice of meetings in any public agency or the agendas thereof. So when you look at that last bullet, obviously the superintendent may have all sorts of staff meetings. Those are not posted, they don't have to be. As long as those are staff meetings, administrative meetings, they're not covered by the FOI statute. So you can be okay with that. The last bullet on here does relate to the question that was asked earlier, which is you can have communications that are limited to notice of any meetings or the agendas thereof. So clearly, if the assistant to the superintendent needs to find out whether all board members can be available next Tuesday night for a special board meeting, clearly that kind of communication has to go on. Otherwise, you'd have to have a meeting to find out whether you can have a meeting. Kind of silly. And so that kind of communication, yes, I can make it, no, I can't make it, that kind of back and forth is okay. There also is a reference to, again, the question earlier, communication is limited to the agendas thereof. There can be some communication on the agenda, but I think if you're going to sit down, frame the thing, I don't think that's what the FOI Commission has in mind in terms of being exempt from the FOI statute altogether. So those are the basic exemptions. So if you have one of those, what that means is you're not subject at all to any of the FOI requirements, none whatsoever. So again, just as an example, the collective bargaining issue, no agenda, you don't have to post an agenda, you don't have to notice the meeting at all, there are no minutes of the meeting, none of those requirements apply. If you're in a situation that is not a meeting at all under the FOI statute. So, I'm going to, I think, stop there and let Jess move. No, one more.
While you're still there.
Oh, sure.
Our bylaws say board officers, chairperson number 2. Meet with the board officers and consult with the superintendent in the planning of the board agendas. Is that, if that was to be done, would that be classified as a meeting subject to?
Let me look at that issue. What I'd like to do is look at your bylaws and look at that specific question and see whether I think there's any need to change anything in the bylaw or change anything in the practice.
Okay.
And I'm happy
We
to
actually brought that to Shipman and Goodwin when we were brought up on the original FOI situation with the Waterbury Republican. And we were informed, and that's when it stopped. Prior boards always had the 3 leadership get together. We have not done that since we spoke to Jessica, and she said that we can't get together because it's a meeting. So that practice has been suspended, but we haven't had a chance to review the bylaw.
Yeah, so the bylaw itself, I mean, your practice seems to be fine. Your bylaw, maybe we should look at the bylaw itself.
I mean, there's nothing wrong with the bylaw, just the board would just need to know that if this was to take place, then it's a meeting, or potentially.
Correct, then you, exactly, yes, and then you'd have to notice it, exactly, yeah, exactly. So, this last one that I'll do, and then Jess will step in, and then we'll go back and forth a little bit. Again, in general, you have a meeting, we've covered this, anytime a quorum of a public agency, and again, public agency means the full board or a committee, to discuss or act upon a matter for which it has responsibility. Sometimes we get this question, not from Torrington, so I'm, again, speaking hypothetically, we get this question. Well, is it subject to FOI if we're not actually taking any action? We're just talking, we're just discussing, so there's no action taken, so what's the issue with the FOI statute? Well, if you look at that, anytime you have a quorum getting together to discuss or act upon, because again, the whole premise is the public has a right to see that. They've got a right to see, whether it's just the discussion, or whether you're gonna take the vote, or some combination of the two, the public has a right to see that. So, the fact that it's just discussion without action doesn't save it or exempt it from the FOI statute. And again, we included this note at the bottom there, we talked about this. A quorum who are present in any event which has been noticed and conducted as a meeting of another public agency shall not be deemed to be holding a meeting of that other agency. So again, as long as there's no purpose at the outset to really have a full-blown board meeting, but call it a committee meeting, you should be fine. For example, if you think about it, suppose you all decided to go to a meeting of the town council or some other the town wetlands commission, for whatever reason you decided to, or planning and zoning. You all showed up. You're interested. You've got every right to do that. No problem with that at all. That's not something that requires a board meeting to be posted under the FOI statute as to Tori before that. So.
Might make more sense for me to just stay here. I'm happy to just stay here.
No, go ahead.
You sure?
No, that's
Okay.
But actually, it's up to you, Jen. You want to
Yeah,
just
I'm happy
stay
to
there?
stay
Oh,
here if
fine.
that's
Sure.
okay with everyone. So Rich talked extensively about meetings, so I'm not going to get too much into the use of your telephone and the use of emails and how that may constitute a legal meeting. But things to think about when you are using your telephone or your email. There are two elements of meeting, right? Is it communication among a quorum, and are you discussing or acting upon board business? So I want to get to the more substantive portion of our presentation, so we can come back to that. A lot of what I'm going to talk about very briefly is going to be a review for many of you, and then we're going to get into executive sessions, and then we're going to get into agenda items, which I think is probably more relevant for what you guys deal with on a day-to-day basis. Some of this will be more review from the administration. But under FOIA, your meetings fall into one of three categories. You have your regular meeting, your special meeting, your emergency meeting, and I will go through this very quickly because it is probably review for many of you. But you need to be careful to comply with these obligations under the statutes. So your regular meetings, you must file with the town clerk by January 31st for the ensuing year, which I'm sure you are complying with. Any meeting conducted for a regular, any business conducted for a regular meeting has to be posted 24 hours prior to the meeting in your regular office or place of business. At that meeting, at a regular meeting, you may add new business items if you have 2/3 vote of those members who are there present and voting to accept to add that new business item. Obviously, you have an obligation under the statute that the minutes must be available for public inspection within 7 days. This is very important to comply with. There are some FOIC decisions which have said that if you don't comply with this 24-hour notice rule, even if you do everything right at that meeting, they will declare your actions null and void because you did not comply with the original posting requirement, and therefore the public did not have sufficient notice of the meeting and the business that's to be transacted at that meeting. So just things to be aware of, even though it seems pretty straightforward. Your special meetings, again, your special meetings are those meetings that are not included on the list of regular meetings, right? So you again have an obligation to notice these meetings at least 24 hours before the meeting convenes. These are distinguishable from your regular meetings in that you cannot add anything to the agenda. So all business posted on the agenda is the only business that can be conducted. There is no 2/3 voting exception here. Again, the minutes of your special meeting have to be available for public inspection within 7 days of the meeting. You then have your emergency meetings. Now, just a word of caution, this is very strictly construed by the FOI Commission. So it would have to be not necessarily an emergency to you, but me as a reasonable outsider, would I deem that an emergency? If it is actually an emergency, there's no advance notice requirement. You could convene within an hour if it really warranted it. The content of the meeting and the action has to be limited to the matter that requires the emergency, and then you have to post the minutes of that emergency meeting within 72 hours, so it's within 3 hours, and it has to include a statement setting forth the nature of the emergency and why you convened the meeting in the first place. We're now going to talk about executive sessions. I'm going to hand it back over to Rich because I know that this is really the meat of what you wanted to focus on. There are specific requirements for conducting executive sessions. They're narrowly prescribed by the FOIA, and I would say that this is where lots of times the complaints are triggered. This is where you see a lot of the complaints, so it's very important to understand what those specific requirements are. And so I will turn that over to Rich.
Okay, and you may be surprised to find out that there really are only 5 reasons you can have executive session in Connecticut total, and there are no others. So we'll walk through these, and again, as Jeff said, these are strictly construed, and again, the reason, I keep emphasizing this, I know, the reason they're strictly construed is because of that premise that things should be open to the public. And so these are very limited exceptions, and if there's an argument they don't apply, you have to be very, very careful because they will be very strictly construed. So the first one, which I'm sure you've done periodically, every board does this, is discussion concerning the appointment, employment, performance, evaluation, health, or dismissal of a public officer or employee, provided that such individual may require that discussion be held in an open meeting. So this is one where the individual that you're going to be talking about, whether it's a public officer or an employee, holds the trump card. And the trump card is that that person can say, if you're going to talk about me, you're going to do it in open session. Now, there's sometimes confusion about this. Suppose you're going to talk about an employee in the district. Again, I'll keep it totally hypothetical. You're going to talk about an employee. There's often confusion around this, and some people construe this to mean, well, the person has a right to come into the executive session. Well, not necessarily. Executive session is a privilege of the board. The board owns that privilege. And only the board decides who comes into executive session. It's totally up to the board. So, in other words, the person can't say, well, you can have an executive session, but I'm going to be there. No. The board decides whether that person can come into executive session or not. If the board says no, you're not actually invited into the executive session, which is possible, then the employee has the right to say, okay, well then, I want to see the conversation, so I guess it's going to have to be in public. The employee's choice is allow it to go on an executive session or have it be in public. But who comes into executive session is a totally different question. That's up to the board.
The employee does not have they don't have the right, they don't own the decision to go into executive session.
Correct. The board owns that decision.
Right.
The board, but if the employee, suppose I'm an employee of the district
Yeah.
and you want to talk about my performance,
Yeah.
and you, superintendent notifies me, Rich, the board's going to talk about your performance next Tuesday night. And we'd like to do an executive session, but of course you have the right to do it in open session. I can force it into open session.
Correct.
And if the board goes into executive session over my objection, then it's an illegal executive session.
Okay, where this breaks down, this happens a fair amount, and I've seen boards of education for 10 years twisted over this to the point of complete inactivity and if the board feels it needs to evaluate the performance of, say, a principal, okay, how much time do we have to notice that person, number one? Number two, how do we have that discussion in public to decide that we want to have that meeting without having that discussion in public?
Well, there's a few, that question has lots of layers, actually. And one of my concerns as your counsel would be that the board has to be very careful. There's only one employee in the district that reports directly to the Board of Education, and that's the superintendent. The board's got to be very careful about getting into performance issues about any employee other than the superintendent. The superintendent, obviously, the board evaluates the superintendent, that's a function of the board to do that, and every superintendent understands that. But when the board gets into discussing performance issues of other employees, there's another risk, totally outside FOI, that is run. And that is, suppose you want to talk about a principal. That principle is covered by section 10-151 of the Connecticut General Statutes, known as the tenure statute.
Yeah.
The board may have to sit in a non-renewal or termination proceeding regarding that principle, depending on what the issues are. If the board has pre-discussion of that prior to any initiation of termination proceedings or non-renewal, which only gets initiated by the superintendent, then there's going to be an argument that the board can't sit impartially and address and conduct that hearing, the non-renewal or termination hearing. And so our advice frequently, almost always, is that the board shouldn't get involved significantly in performance issues of employees other than the superintendent. Now, there may be other central office employees, there could be some exceptions to that. But basically, because the board may have to sit in a hearing capacity certainly for certified personnel, all your teachers, all your administrators, also for coaches, because there's a coaching statute in Connecticut that you probably know about, where coaches, as long as they've coached three consecutive seasons in the same sport, they have a right to a hearing before the board, concerning non-renewal or termination. They've got a right to an impartial hearing before the board. So as a matter of due process, and I don't mean to go off the track, but as a matter of due process, we would be concerned that if the board's going to talk about the performance of a teacher or administrator, the board may be compromising its own right and its own ability to give that teacher a fair due process hearing, which I realize creates a problem operationally sometimes for boards. But it's something that's very important because, again, suppose, just hypothetically, the board has the conversation about the principal, and the board is very critical of the principal, and the superintendent then recommends non-renewal or termination, and then there's a hearing. The principal's probably going to claim, I can't get a fair hearing, because I know there was conversation because you notified me, because you had to, that there was going to be conversation. And so we have to be very careful in those situations.
So how's the board, let's say there's an issue where the board needs to get information about what happened. There was a lot of anecdotal information that came by way of private citizens, parents, students, other teachers, for instance, regarding how a situation was handled. The board wants to get down to what really happened in this situation. And the only reasonable way to get to that is to talk to the administrators involved.
Well, talk to the superintendent. I mean, what the board can do there is have a conversation with the superintendent about that issue in the context of her performance, for example. That can be done. If it's a student matter, there may, and we'll talk later about some, when we get into the roles and responsibilities issues, there are student discipline matters that end up coming to the board for expulsions or other issues, but you've got to be very careful. And really, again, it's the superintendent who reports to the Board of Education, not those underlying principals, which is no disrespect to any of them. They have critically important jobs, but they report up through the superintendent, either directly or in some cases indirectly.
So the proper way to handle that is to schedule an executive session and possibly multiple follow-ups. In other words, if you want to find out, so you ask a set of questions, the superintendent then has to go and sit down with the administrator or administrators to present the board's concerns to these administrators. Why did this happen? When did you know this? How did you do that, handle that? She reports back, in this case, she reports back to the board. The board has another executive session, follow-up, has follow-up questions. The board has to then ask the superintendent to go and ask follow-up questions.
Well, again, I mean,
is that really,
well, but again,
really this is the process.
Well, but again, the board shouldn't be getting, if the board has concerns, again, I'm going to talk totally hypothetically here. If the board has concerns about, and I'm going to take Cheryl out of it, a superintendent, past, future, or whatever, a superintendent's handling of a matter administratively, the board has the right to address that with this superintendent or whoever the superintendent happens to be, and say, we want to understand how you address this issue. We understand there were concerns, parents filed complaints, and we don't understand, what did you do to handle this matter, or how was it handled at the building level? And who knows what you'll find out. Maybe you'll find out that she was dissatisfied with the way that was handled and she's addressed it in certain ways, or that she believes it was handled appropriately, and the board may have a different view of that. But it's really, what you're really doing is having a conversation with the superintendent about her handling, her holding people accountable. Okay. And that's really the way to do that.
All right.
So.
I'm just wondering, say for example, a board were to hold an executive session regarding security, and the superintendent has been charged by the board with implementing a different type of security. And what I'm really getting at is, at what point is it okay, or do you cross the line during the executive session of evaluating the superintendent without having noticed the superintendent that can be evaluated, might be evaluated? I mean, do you have to run the risk? What I'm getting at is, if you're evaluating the superintendent in executive session, if the executive session is not to evaluate the superintendent, is there a line that you crossed in so doing? Or?
Not necessarily. I mean, obviously there's a formal evaluation process, and that would be, you want to follow your formal evaluation process to do that, to do the actual performance evaluation. You can be discussing any issue with the superintendent, take the security strategy or whatever the issue happens to be. And if the superintendent's response is somehow not satisfactory to you, or you have issues with it, you can sort of express those issues. That's not evaluative itself. Later, it could, the board may, that may play itself into some evaluation conversation. But, I mean, just as the superintendent, for example, may be having a meeting with her administrators, and she may be dissatisfied with one administrator's explanation of enforcement of curriculum at a certain school, she's not going to evaluate in that meeting. She may express politely and professionally and respectfully some concern about what's happening at that school, and she may take it up later with that administrator to say, look, I wasn't too happy with the answer you gave in that meeting, it was kind of embarrassing, or whatever the case may be. So I think it's different. You can certainly express and process information related to whatever the concern happens to be, but the evaluation piece really comes later. With, in this case, the superintendent, and in her case, for example, with her administrators or whoever happens to be the subject of it.
Just to follow up on the example of so-called principal, board's concerned that like there's an issue going on, and now we say, go into executive session, give us all the details of how the principal handled the event on June 1st. We hear everything and we say, you've given us enough facts that we want you to now engage in termination proceedings. Okay. So now we're no longer going to be able to be the hearing officer.
Right, but here's the problem.
Okay, no.
Yep, go ahead.
And let's just say that is the next, that's the result of that. So what? Does that now become a bar that principal is no longer allowed to be disciplined? Or is there another procedure, statutory procedure, in which the board has relinquished that right to be the hearing officer, but now there's another procedure in which a neutral hearing officer or person will come in and perform that function?
Here's where it's a problem.
Okay.
Take a tenured certified person, teacher or administrator, doesn't matter, because they're covered by the same law, and you have that conversation. And you tell the superintendent, you got to start termination tomorrow. That's what we want to have happen. That administrator, certified administrator, has a right to a hearing, a fair, impartial, due process. I mean, this is constitutional due process now. A right to be heard impartially. And that, if it's a tenured person, that person has options basically, at least with the current law. The options are hearing before the board. It's up to the individual. Hearing before the board, hearing before one impartial hearing officer, not part of the board, or at least for one more year, a three-person panel. Impartial people, not members of the board. So you might say, all right, well, we'll just go that direction. That'll obviate the whole problem. Here's the problem. By statute, and this is not waivable, not changeable, nothing you can do about it, the board still makes the final decision. Even if there's a hearing officer involved. Let's assume the administrator, and by the way, most tenured teachers administrators don't want their hearings before the board. They want their hearings before someone impartial, outside. They believe that that'll be their best shot in a termination case. So most likely, they're going to choose an impartial hearing panel or impartial hearing officer. That officer or panel's charge is to conduct the hearing. The board members would not be there, hear the evidence, and make findings of fact and a recommendation to the Board of Education. The board is bound by the findings of fact, but not bound by the recommendation. So the board can do what it wants, as long as there's a reasonable basis for it. And the problem is, if we literally have a situation in which the board has directed, essentially, the superintendent start termination, how could that person possibly get a fair decision by the Board of Education? I mean, the board has, the argument would be strongly that the board had predetermined the whole thing. And so that individual, that teacher or administrator, their argument legally is going to be very, very strong in a court. Let's assume the board terminates. The findings of fact, yeah, there's some misconduct that occurred or some bad performance. And it almost does, suppose the recommendation is against termination and the board votes to terminate. we're gonna end up in some serious litigation. And there's gonna be a claim that the Board of Education couldn't possibly sit impartially to make that final decision because the board had prejudged and predetermined the whole thing.
I'm still not really seeing the downside in the sense that if, let's use a really extreme case.
Yep.
I hear Johnny, teacher, is a pedophile. And these are the facts. We go in executive session and we say, these are the facts. Superintendent says, yeah, I got the police report. These are the facts. And we say, but the superintendent may be hesitant, you know, we don't want to be involved in litigation. We don't want this to, whatever reasons, just thinks in the broad picture, this isn't good for the school district. The board says, nothing's more important. We want this person terminated. Now you're saying that the person's going to have a right to an impartial hearing officer, and then it's going to come back with the recommendation, terminate immediately.
Or not.
Or not.
Depends.
Okay, well, that's probably
Depends on
something
the evidence.
society should know.
Well, it depends on the evidence in terms of.
Well, yeah, I mean, it's, okay, and then we follow the recommendation. Now the person's going to appeal to where? Superior Court?
No, well, they've certainly got the right to appeal to Superior Court all the way up to the Connecticut Supreme Court, but
Okay.
more importantly, they have the right to file a federal district court action for a constitutional due process violation.
And what was the constitution?
Because
Because we had the right to do it.
No, because the board predetermined the outcome. The way to avoid the litigation, and again, I'm gonna say, I would say this to any board and any superintendent. I just want to be clear on that. The way to avoid that litigation is to trust the superintendent to make the judgment as to whether or not termination should be initiated or not. I mean, if Cheryl called and said, I'd like to talk with the board tomorrow night about this serious, because we may have a pedophile, and it's horrible, I'm mortified by this, and I want to talk to the board to get their input on how I ought to handle this, because I'd like to vote for termination, but I want to kind of see what the board thinks. I would say, Cheryl, you absolutely should not do that. And if Ken called and said, we'd like to have the board have this, or if whoever was the chair, doesn't matter if it's Ken, said we'd like to have the superintendent report on this because it's troubling our community and we want to understand what's happening, I would say, Ken, or whoever the chair was, you should not have that conversation, because what you're going to do is weaken the administration's ability legally to pursue termination or whatever else they think is appropriate. We're trying to keep you out of litigation, make sure that the person has, and by the way, let's assume the facts are true, that the person's a pedophile, they're a harm to children, we want nothing more, we want the same thing you want, which is we want this person gone, probably lose their teaching license, etc. We want all that to happen, but we want it to happen procedurally correctly so that it's not subject to challenge. I will tell you honestly, in teacher termination cases like that, just like expulsion hearings, the thing that you can do that most causes the problem is a violation of due process. If you do things procedurally correctly, you stand a very, very strong shot of having your case upheld. If you don't, that's when you get into trouble. And there's lots of case law that backs that up.
Well, can I ask a follow-up? Just maybe go about the same thing a different way. You're here to represent the board, correct?
Sure.
You're the board attorney.
Yep.
What I would like to hear, I've heard for years and years and years and years, all the things that Board of Educations cannot do, okay? In terms of getting rid of underperforming and or, forget about pedophilia, we're just talking about building a functional, high-performing school district.
Sure.
And where we find that and we know that there are underperforming and or incompetent and or burnt out administrators who are simply not doing their job and doing it to our expectation. How should a Board of Education go about what are the steps for removing that person?
Again, I think the first step for the board is to have that conversation with the superintendent. And the superintendent, I mean,
Under what condition? Executive session to discuss? If a board member says, look, I've had it, you know, we bent over backwards trying to do this, that, and the other thing at this particular school, and I've just had it. What's that board member to do?
well, again, if presuming that, let's assume that there are, that it's absolutely correct, that there are real issues at one school in terms of leadership of the school, there's underperformance, poor performance. The administration should be addressing that, obviously, in terms of, and now the Connecticut evaluation with education reform, it's always been possible to move out, always been possible to move out administrators and teachers.
You know as well as I do how extraordinarily difficult it is to get that done.
I actually, it's not easy, but I actually think it's not as hard as people have said. And there are many school districts that have moved out, usually without a full-blown termination hearing, because they've usually moved them out.
Talking to a district that had that problem, it wasn't a simple process, and it was taxing to the emotional welfare of the board members and monetarily taxing to the taxpayers of the city of Torrington. So I'm not positive where you're coming about, but this is an easy process.
No, I would never say it's easy.
easy.
I would never say it's easy. It's not an easy process for sure, but it is, districts have done it, and districts, I mean, there are districts that really hold, I'm not suggesting that you don't do this here, but if you hold people accountable for their jobs, board, superintendent down through the hierarchy, if people are held accountable for doing their job and doing those jobs effectively, there are tools in place, and now increasingly so with education reform, to move those people out. I'm not suggesting that it's easy, and I never would, but it is doable, and districts do it.
How does the board member then, so step one is informing the superintendent. That has to be done in executive session, correct? If a board member has.
If you're having a conversation about the superintendent's performance.
No, at a lower level administrator, so we have to work through the superintendent. So a board member requests an executive session?
Well, again, if you're gonna have a conversation about a specific principle, you're gonna have to, again, we've got the issues with the 151 process that I just went through. I think the starting point is the conversation about the superintendent's, holding the superintendent, again, I'm not saying this about Cheryl, I'm saying it generally about the office of superintendent, that position, that you've got the right as the board to hold the superintendent accountable, just as she holds her administrative team accountable, just like every principal should be holding every teacher in the building and every employee in the building.
But that happens once a year, that formal.
It doesn't have to happen once a year.
Okay, so let's say it doesn't. Let's say school year begins end of August. Let's say by November, we know we've got a situation, okay? The same school, the same sort of person, and we want to know what's being done about it. I request that we have an executive session to discuss.
Well, it's really a discussion of the superintendent's performance in holding people accountable. That's really what you're talking about.
All right, so then we have to have. I'm looking for a punch list of what to do.
Then you
so
have
the board has some authority over its own school district.
Then you have that authority through the superintendent.
Okay, so we request it. Okay, and how do we form it? And that's as much as we have to say in public, correct? I mean, we can't evaluate the other person for the
you can evaluate the superintendent in executive session, subject to her right to have it be an open session.
But then you can't go into the details of whatever the board members are unhappy about.
What I just want to know what technically has to happen, so we don't have to tie up a board. We've got you here, we've got two attorneys sitting here.
Sure.
What technically does board member have to do? If in November we want to talk about a given administrator that we think.
I think you should have a conversation with the superintendent about what she is doing.
In what process? We request an executive session with her?
Regarding the superintendent's.
Yes,
performance.
evaluation of this particular school.
No.
Regarding her.
Me,
Regarding her
me, you
performance.
have to tell me, Cheryl, you're not doing a good job of
Correct. What I'm saying is-
supervising this principal.
Right, all I'm saying is, in the public session, to request that executive session, literally what are we asking for?
Well, no, you would, in the agenda setting process, you'd recommend through the chair, request from the chair,
Okay.
that an item be added to the agenda related to the superintendent's performance. You would
Okay,
then
fair
have an
enough.
executive session, you notify Cheryl, obviously, that you're gonna do that, she has the right to require that it be an open
I'll
session.
finish the process. He would ask me to add it. I
Correct.
would ask Cheryl if she wants it in open or closed.
Correct.
And then we would set the agenda and go.
But I have to give some indication of what that meeting, I mean, it's about,
You have a
but it's
conversation with the-
about, it's not really evaluating.
But it is. I mean,
Okay, but how do I explain, just say, so
has
generically, so
You're
just generically,
frustrated, Paul.
okay,
Yeah.
okay, no, but, so therefore, if we ask for an executive session to evaluate you, you're gonna realize that that may be not specifically how you are, but it's somebody under, we're trying to get down to how somebody under you is.
But
But-
we can't
but-
get that.
go back-
But
But
that's-
really, the
That's
issue
what we
is
can't
really,
do.
is how the
That has to be-
superintendent and her administrative team are, let's assume there's some.
Handling a situation, right.
Handling a situation.
But
Trust
how do
me,
we know
it's-
that? How do we know that they aren't writing up these principles?
Well,
We don't know
that's
that.
what she would share with you. She would,
But then is that evaluative of the principal
she,
writing up?
again, you have to be careful. She can certainly describe in general terms what she's doing. She's not gonna wanna get heavily detailed because again, we run into the same bias problem. But you can have conversation generally with the superintendent about how she's handling certain school leadership issues. You can have those conversations with the superintendent. You can have those conversations, and boards do that.
Well, there's only one principal at an elementary school, and the board member has an issue with that one principal. How do you have that discussion without noticing the person?
What the board should be assuring itself of is the superintendent, it is her administrative team, are they taking appropriate steps to address an issue? And either they are or they aren't. If they are, then she can share with you, at least in general terms, here are the steps that I'm taking to address this. If she's not, then obviously that's an issue between the board and the superintendent in terms of her performance.
Do we have the right to know if she's writing up a principal?
In general terms, yes. Again, I would not want you to get overly specific.
Like I couldn't show you.
Right. There's case law in Connecticut that says if a board member reviews the performance evaluations or other disciplinary documents of a certified staff member, that board member can't sit in a termination hearing. Because again, the whole premise is you have to be able to get a fair hearing.
And just to add to that, Fiona, there's a specific state law which exempts teacher or principal administrator evaluations from disclosure. And you as a board member have no greater right to access of that evaluation than a regular citizen, so it's something to think about as well.
I'm just trying to figure out how this would circumvent out if people want to evaluate the superintendent, but really because they want to find out about someone else in a building. How do you even have that discussion? That's what I don't.
I think you can have a general conversation about how the superintendent is addressing an issue without getting into every minute detail of the issue.
So what if it comes up that she or he has written them up multiple times? That's not.
That fact alone, is that going to cause the board to be biased? No, I don't believe so. But it may assure the board that yes, the administration is looking into the issue.
The other piece too is 10-151. So even if the board wanted to eliminate, or reassign or whatever, a principal, or say, no, you can't be a principal by statute, they still can be a teacher. Or they can say if they're a principal, the least, make sure I'm saying it right, but the least seniority administrator they could bump.
No, I get all that. And like I said,
And they have contractual rights to the
Right,
administrators based
right.
on their contractual.
honestly, after 10 years of doing board work for 10 years, the single biggest failure to me, in my personal opinion, has been the inability of boards of education to really hold administrators. Everybody points fingers at teachers, teachers.
Sure.
But the weak link, the failure point here is at the administrative level, and it's the inability. It's just this complete being hog-tied, trying to get what we really want out of the performance that we want. It's so very, very different than what's available in the public sector, and it's why the public sector succeeds, and it's why the private sector succeeds, and why the public sector is just so damn stuck in the mud, and it's extraordinarily frustrating, and nothing else that we do. This entire administration reorg of our school district, a huge, advance that we're putting forward this year. None of this matters if we have underperforming, incompetent people doing this.
I think it gets back earlier, Paul, to the point of how we're now moving the board goals that we would evaluate the superintendent on into another session in August, when that's how you would do it. Like one of them we were even looking at was reducing the amount of discipline stuff. Well, if discipline's going up and we keep hearing about issues, that's how you evaluate the superintendent, because she can move that down through the administrators as she moves her goals down.
But I would just like the whole board to be on the same page, literally knowing the procedure for doing this, so we're not, because what happens, I've been through this so many times, what happens is that somebody says, oh, we can't do that because of this, or just have 151. And then the conversation loops around, and by the end of the day, nothing gets done, because we end up calling up our lawyer, and then, not you, but other attorneys will advise us in the past that, well, you really can't do anything. At the end of the day, you hang your head and you go and you pretend like you're making
Yeah, I mean,
advances.
certainly there are school districts that have moved out, I'll use that word, that term, administrators. That doesn't mean necessarily there's been a full-blown termination hearing. But the people have left, or there've been settlement agreements, or that, I mean, those do happen, absolutely.
Oh, Joe, we've been through them, yeah.
I understand. So, and again, I think, I would never say it's easy, because it's absolutely not easy. But there are tools, and I think increasingly the tools are there under education reform. We'll see. I mean, the education reform in terms of termination stuff doesn't kick in until next July 1st, when they're gonna really shrink the termination process. So we'll see. But I do think that the pendulum has swung back in favor of accountability for these very reasons that you described.
Thank you.
Sure.
The most disappointing part of listening to you talk on this subject is that you totally make me feel that as a board member who's supposedly overseeing for the public that this school district is being run at a certain legal standard, certain policy standard, that we have really no ability to find out the facts about what the staff is actually doing at any level in any of these buildings.
I don't think that's totally accurate.
Well,
I think
we can't ask her about Principal Joe or Teacher
I mean,
Bob.
you can find out. You've got the right to data about how schools are performing,
Well,
test
data,
scores, all those sorts of things. But, and again, in general terms, you can certainly, I mean, for example.
How do we evaluate the principal when we don't, when we hear Principal Joe or Teacher Bob did X, Y, Z, and we want to know, and all we do know is, yeah, we heard that, and we know that both of them are still employed, have no idea what the superintendent did, and we can't ask the superintendent to explain the facts of what those two people may or may not have done. So we can't evaluate, why didn't you terminate? Why didn't you do the paperwork to start the process or discipline that person as each step required? How do we evaluate the superintendent? We can't ever find out what the superintendent is actually doing.
Well, you can certainly get aggregate information, for example.
What information?
About your administrators, for example. I mean, you can.
No, we're not concerned about what the general school's doing. We're concerned about a specific act that is a public notice to all the kids, all the parents in the district. The only one who doesn't officially know is the Board of Ed members. Everyone else in the community knows, and we can't discuss it, even though the whole community is concerned, because they all know.
Because you sit in a unique spot where you may have to make a decision in a hearing process. Now, if you know that that hearing process is never going to occur, because the decision's been made short of termination, then there may at some point, let's assume it's very clear that the superintendent decided not to pursue termination in a particular case, for whatever reason. There may be some limited conversation that could go on with this, after that's already been made, that's not gonna change. It's not going to change. There may be some limited conversation you could have with the superintendent as to why that didn't occur, in a very limited way. You can also, there are boards that get aggregate information about administrator evaluations, not individual evaluations, but have they all been evaluated, period. Do they even have evaluations on file, number one. How many were rated, exemplary? How many were rated, you can ask that data. That gives you some sense. Suppose you found out they were all rated the highest rating, and you happen to have major concerns about 2 or 3 of your schools and the leadership of those schools. You have a conversation with the superintendent. How can it be that you rated all of your administrators X when we have these serious concerns at that school? How can that be?
But how is that fair when people are hearing things out in the community, but they don't really know what really happened? So if you're told by Johnny that this happened, but you don't really know if it happened, you're not getting the information, did this really happen or not happen? How do you then say you shouldn't have evaluated them? Without knowing what actually happened. I mean, that's what I don't get.
I mean, that at the first level, it's got to be referred, if you hear of something, it's got to be referred to the administration.
Well, we don't know if it's been because the administration won't tell us that it was referred to them. Because we have no right to know that.
Right.
At the end of the day, what I'm concerned about is really the relationship the board has with the superintendent. which may or may not be fair, and it's really not fair to the superintendent in a lot of ways. If what you're saying is gospel truth, do everything the way you say to do it. I'm going to say, I'm not going to ask the superintendent any of those questions. What did you do with Principal Joe, Teacher X? I'm just going to, when her contract's up, sorry, we're terminating your contract, you're done. And it may be that the information that if she could have supplied to us may justify my changing my opinion, but because of what you're saying, that as a board member, in my unique position of not being able to know anything that goes on in the school district, I'm going to terminate her.
I don't think it's quite as black and white as that.
And that's the truth.
Well, I don't think it's as black and white as you suggest.
Well, that's the way you said it.
I don't think so.
Okay. Give me the gray area then.
I've said a number of things. I think the superintendent can share some basic information. She cannot get into nitty-gritty details about a particular case, that is true, but she can share some information with you. And I think you do have tools, and districts do it. Districts clearly evaluate the superintendent, and they get into issues, at least generally, about how the superintendent is holding people accountable in these school buildings. I mean, you're right, every one of your administrators needs to be a very good, highly performing administrator, no question, to carry out all the things you need to carry out here. And that falls to the superintendent to do that.
But now say, and this will be my last question, now say we have a board attorney who we feel is super aggressive and really views his legal position with being an advocate for the Board of Education, not the superintendent, not for the state, but for this board. We say, we hear this problem. We want you to do what you legally can do on behalf of us to ascertain this information as our attorney and give us this information.
But it's no different. That's really no different. I mean, that's the same thing as the superintendent talking to you. If you get, it doesn't matter how you get it. It's the getting of it that becomes the problem. If you become totally aware of the facts of the matter because your neighbor told you or a friend told you, it's the same thing. It's the access to that information in that detailed way.
That information would be worthless because it's coming from just a source that's not in any way legally valid, or it has that no legal real.
Yeah, my point, I guess, is that no matter how it comes to you, it's the access to the information that causes the problem, the detailed problem. If there's going to be a non-renewal or termination hearing.
I don't believe this. We're the only board in the state of Connecticut that poses this question every time you come to one of these boards.
No question. And there,
you know.
I agree with you completely. There are boards that do this. There are boards that have conversations with the superintendent about these issues, and they get somewhere in terms of holding people accountable to do their jobs. And that's the superintendent's job, is to hold her administrative team accountable for doing their jobs, just as it's your job to hold her accountable to do hers. And there are boards that do it. And there are boards that get aggregate information. There are boards that have general conversations, so they have some. The bottom line is, you want confidence that your administrative team is in fact holding people accountable. And if you have to decide, that's a function for the board to decide ultimately. But that's what you want, is the confidence that in this case, that she is doing that, superintendent is doing that.
Do boards typically get involved in working with the administration to get an evaluation tool for the administrators, or is that solely the prerogative of the superintendent?
You mean the actual tool?
The evaluation tool.
Well, the evaluation plan ultimately, typically, was that plan approved by the
Yeah,
board?
I've got it right here,
Okay.
you know, but it's now, the state is telling us how to do it. And
Okay,
it's
so
based
that's your
performance.
blueprint.
Pardon, yes, it's based on, performance.
Is it a 5-tier? 4-tier? What-
Four.
4?
Four.
Okay, so
And
that's
it's-
what you're saying, is
and-
how many meant 1, 2, 3, and 4?
And that's not part of,
Yeah.
but that's not part of the administrative evaluation right now. Ours right now for Torrington Public Schools is did a principal meet a goal or not.
Oh,
Okay?
really? Is it-
2 goals, actually, I put 2 goals, not just 1 goal. But what's gonna happen in the future is, and I just had
Yeah,
it
that's
here.
for like private sector. You got 4 goals. I mean, okay, I got it.
No,
No, you got 4, not 4 goals, 4.
4 ratings.
4 ratings, 4
Right.
tiers, okay, got it.
And that plan's fine. I mean,
And-
there's no-
Okay.
And what happens is
And that
based
starts
on,
next year?
Well, that-
right now, it's
It'll
starting
start 13, 14.
July 1, it
Okay.
started. But it
Okay.
shows You have to decide through data, through numerical, through student performance. You have to
Yes.
show, demonstrate where the administrator, and it's the same for a teacher, where they fall on this grid.
So we
And
can
come
have a-
up with an evaluative.
I got it. So we can have an executive session, and we could ask you to plot that out, and then we can just get general data without referencing anybody in particular. But we, how
Right.
many met this, how many at the elementary school, how many at the assistants
Yeah.
met?
Yes, I can,
And
right
we'll-
And
now.
all that stuff, and that will be a
Okay.
clue.
Aggregate
Right,
information.
right
Understood.
now
Thank
though,
you.
I
Okay,
can
okay,
share with
I
the
got it.
board, without saying who, where, or what school. I can tell you based on the goal that the teachers, the principals set, how many achieved that goal and evidence of it through student assessment, and the other one was involving families into the learning process with their child. And I can cite examples.
Yes,
of
don't need
it.
an answer. I just want to know going forward, because clearly, in order, for you to be successful at doing this,
Absolutely,
you gotta have the right people doing it, and we all know that, you know,
yes,
we have some question marks there.
yes.
Okay, fair enough, thank you.
Sure.
I have just a question on executive session.
Sure.
If we're unsure if the information is regarding performance health, for example, if the union requests that a grievance be held in executive session because they're gonna talk about one of those specific things, but we don't have the information to actually know if it is about one of those specific things or not.
It's ultimately, well, okay, it's the board's decision, not so much the full board, it's the board's decision
I'm
whether to go into
specifically
executive
agreeing.
session. What's that?
Just for grievance.
Right, it's the board's decision whether to go into executive session. Unless the board, and grievances get a little tricky, back in 1997, the Supreme Court decided on Waterbury Board of Ed case, and they held that the evidentiary portion of grievance hearings, that portion has to be held in open session, so the public is allowed to come, unless there's an exemption that applies like this one. So for example, if the grievance is about a 5-day suspension of an employee, clearly it's about the performance of that employee or the conduct of that employee. That grievance, the evidentiary portion, could be held in executive session, subject to that employee's right to have it be an open session, because that's an individualized grievance about his or her performance. And so that one would fit within that first bullet
But
exemption.
we don't know what the grievance is about.
The administration would know that. No, that's up to the administration. The administration needs to decide ahead of time, is there a basis for this grievance to be held in executive session or not? Many times there wouldn't be. If there's a question about the calculation of insurance premiums, that's clearly not executive session. That's not about anybody's performance. That's got to be held. The evidentiary part has to be held in open session on that grievance. But if the superintendent, for example, whoever's handling it for the administration, believes the grievance may relate to an item that fits within number one, she would notify the employee and or the union. We believe this case is subject potentially to executive session. Is that what the employee wants, or does the employee want to hold an open session? And that conversation would occur. If you didn't have any reason ahead of time to know it may fit within that box, and somebody says something during the grievance hearing that might lend itself to that box, you could then do an executive session, subject to that employee's right to have it be an open session. So if it's something, I believe I think I'm recalling the situation that arose here in which it wasn't clear.
We've had many.
Oh, okay, but it may not be clear at the outset that there's any basis for a belief that number one even applies there. If something happens during that grievance hearing, you would be able to then go into executive session. You don't have to, as long as that person's there, you'd say to them, look, it appears that you're going into a matter that relates to, for example, your health. There's some medical issue that somehow gets disclosed. You would say to the employee, if you would like, we can have that conversation in executive session. If the employee says, no, I want to hold an open session, then we'd stay in open session. If the employee says, yes, I would like to, it's my medical issues and I really don't want to talk about that publicly, then that piece, and only that piece, could be held in executive session.
But then what if you determine during the evidentiary portion, during the executive session, that it possibly didn't fall under the employee?
Again, if you have a reasonable belief at the outset that it's going to fit within that number one box,
Well, we
that's
would-
reasonable.
We don't see it.
Well, again, the administration's gonna make that
Or
judgment.
HR.
If their belief is reasonable, and then let's say it doesn't somehow, it doesn't, then if somebody files a complaint at the FOI commission, then the test is gonna be, were we reasonable at the outset? Did we honestly and reasonably believe that number one applied? And if so, we should be okay at the FOI commission, even if it didn't turn out that way ultimately.
I mean, our challenge is always, we're gonna end up in FOI either way. If we hold an executive
Yeah.
session, the papers are gonna take us, and if we
Right.
don't, then the union's gonna take us.
Well, remember,
So
there's
it's-
no, it's not an FOI violation to do anything in public. It's the other way around.
Right.
You don't commit an FOI violation by doing something in public. FOI violations are only if you did something improperly in executive session. But clearly, there are grievances that belong in executive session, as long as the employee is comfortable with that.
But
Sure.
going back to Andrew's
Sure.
question about the principal who might have been arrested for, inappropriate behavior with a student. Now, once it becomes a formal arrest, then it becomes illegal outside of the school's jurisdiction. Do you know what I mean? So,
Well, that's a separate process.
Right.
And we don't tie ourselves to that process.
okay, so we can go, but they're arrested, and until it goes to trial in a court,
No.
that's innocent until proven guilty?
No,
Kind of, okay.
two different things.
Okay.
Employee gets arrested. That's
So
a-
we can deal with
that's a
it just,
criminal
they got
process.
arrested?
You need to,
boom.
right, you don't have to await the outcome of the criminal process. You're not bound by the outcome of the criminal process. That criminal case can get thrown out on all sorts of technicalities. It's a different burden of proof, different standard of proof. Same thing with student expulsions. You don't have to wait until the student is,
Right.
prosecuted
Okay.
or not prosecuted. Case may be nollied or dismissed. You're not bound by that process. I mean, there are criminal cases that go on for years,
Mhm.
and you're not bound either in student cases or employment cases. You're not bound to wait for that. What you would have to do, let's assume you wanted to terminate someone for sexual misconduct, and that was a sexual assault criminal case as well. You clearly would need evidence. We would need to put on evidence in a termination case that actually happened. And as a practical matter, it might be difficult to do that while the criminal case is going on, because we don't want to interfere with the law enforcement investigation or that process. But there are two different procedures, and you're allowed to proceed without waiting, and you don't want to wait for the criminal process, nor do you want to tie your actions. You don't want to say, for example, well, we won't do anything. We'll just leave you out on leave until your criminal case is over. That could take years, and it can get thrown out. Suppose it gets thrown out on some search and seizure issue that has no application to the Board of Education. You don't want to tie your hands that way.
And Cheryl, that's the same thing with DCF, so lots of times we get the questions, do I have to wait for DCF to substantiate this allegation? Do I have to wait for the appeal process if they are put on a registry? And if you have enough evidence to record, you're not bound by DCF's findings either.
Well, now that issue's been
Sure.
raised, we're at a policy issue of, do we suspend a kid's rights to participate in athletic events when a student has been arrested for either a misdemeanor or felony in the other world?
Sure.
And it hasn't been adjudicated yet, it may take 6 months. We have the right by policy to say, once you're in the system, we're going to determine that you are no longer entitled to participate on the golf team for the year.
That would be in
That
there.
happens,
Yeah.
the districts do that.
We have to wait? I mean,
No,
that's the
it
big,
should-
I mean, I hear constantly everybody going, well, what happens if the person, if the student a year later, he had a scholarship to Clemson to play golf,
Sure.
but he got arrested a year ago on whatever charges, and we don't let him play golf for that year, and then it's adjudicated in the courts that he's acquitted. What's the liability to the district?
If the district relied on reasonable information and had reason to believe the student engaged in the conduct, the criminal standard, as we know from the OJ case, the kind of best example of it, is totally different, completely different. And that applies in the student expulsion case as well. In a student expulsion hearing, we don't need proof beyond a reasonable doubt. We don't need that in a termination case or the suspension of golf privileges.
You say it so clearly, but yet it's a controversy in this board here of whether or not it's a fair thing to take away a student's extracurricular activities until that kid is
Adjudicated in the criminal court.
in the criminal.
Well, again,
And then you say, well, what happens in it?
our advice generally, not only in towards it, but otherwise, is that you don't tie your decisions here administratively to the outcome of the criminal process. That you make independent judgments based on the evidence that you've got. administratively, whether it's a student discipline matter or, coaching, not coaching, but athletics matter, or whether it's a teacher termination or some other kind of case. You decide that administratively. I'm not suggesting we don't have to work cooperatively with the police, because we do, and it's usually going to be in our interest to do that. Otherwise, we're not going to get any evidence of what the case was about. But that we're not bound by the outcome. And there are employment cases that have been really messed up, honestly, by, and again, I'm not talking about Torrington, where things were tied to a criminal process, and some technicality results in the dismissal of that case, but everything was tied that way, and the administration then couldn't act, which is a major problem. Take your pedophile case. The last thing we want in the world, if we have evidence that occurred, suppose that case gets thrown out on a technicality in the criminal system. Search and seizure, the search was illegal or something. That doesn't affect necessarily the employment case, and we want to be sure to keep those separate.
Thank you.
Sure.
But you would have to have evidence.
Absolutely.
We would
There's
have to.
no question you have to have evidence. Because obviously that in that, even though the burdens are different and it's lower in the any kind of civil proceeding, clearly we have to prove it. If we're going to take somebody's career away because they allegedly molested a child or something, clearly we need, and we should have, a high burden on that, something like that. So, just to keep us moving through the executive session piece. So that's the first one. That's the first executive session privilege. The second one is strategy and negotiations regarding pending claims or pending litigation involving the public agency until that claim is over. So if the Torrington Board of Ed has been sued, you're allowed to, or you're considering suing somebody. Either way, you can talk about that. Obviously, you don't want litigation strategy talked about in public. That would compromise your position and compromise the community potentially. And so you're allowed to talk about pending claims and litigation in executive session. You would have to, again, it's only pending claims and litigation. It can't be something that is hypothetical. It's a very specific kind of exemption. Then we'll move to the next one, which is, this one actually has gotten a lot of use over the, tragically, given the Newtown situation and other tragedies, matters concerning security strategy or the deployment of security personnel or devices affecting public security. There is an exemption. Under this exemption allows you to talk about security strategy because obviously there may be things about that strategy that you don't want students, for example, to know about or employees to know about. So you can discuss security strategy and do that in executive session. The next one, which doesn't come up too often in the Board of Education, mostly this would come up in a regional district or really the town, discussion of the selection of a site or the lease of property if the disclosure of the site would increase the price. So if you, let's assume you're a regional school district or you're the city of Torrington and you're considering buying a piece of property, you don't necessarily want the owner of that property to know that that's your #1 spot because that may jack up the price. You're allowed to talk about that in that limited case. You can talk about that in executive session. And I said there were 5. This next one is the last, and in some ways it's the biggest. Discussion of any matter which would result in the disclosure of public records or the information contained in those records falling within section 1.2.10 of the statutes. That is basically the confidential records section. So for example, you'll notice that I didn't say anything about student confidentiality up here. It's this last exemption that allows us to do that, because in an expulsion hearing, we're discussing confidential student records. The events of what happened with the child, student's academic record, discipline record, that's all exempt under 1.2.10. So the catch-all, which is really what it is, which is this last one, is if we have a document that we're going to be talking about that is not disclosable under FOI, we can talk about the document in executive session. That's why I think we've probably laid out your expulsion hearing procedures for you. That's why you'll note that we say that the reason for executive session is discussion of confidential student records. That's why we use that terminology. Similarly, I think from time to time you've requested that we write opinion letters as your legal counsel on various subjects. That's because 1.2.10 allows you, it provides for the confidentiality of written legal opinion. So you can talk about the written legal opinion in executive session. So those are, believe it or not, that's 2 slides, that's all the reasons that you can have executive session, only those 5. This last one, again, encompasses a lot because there are a lot of records that are exempt under the statute, but that's it in terms of executive executive session. Those are all the reasons you went to executive session. Now, under the statute, as you know, and this will just really be a refresher, I think, for everybody, there are requirements under the FOI statute for how you go into executive session. One is you need 2/3 of those members of the public agency present and voting who must vote to go into executive session. And this is the part that some boards, not Torrington, but some boards don't always do this. You need to state the reason for executive session when you do it. So, for example, take the expulsion hearing. We would suggest a motion to go into executive session for the purpose of discussing confidential student records. That's the reason you're going to do that. Or to discuss an attorney-client privileged communication regarding the meaning of our bylaws, something like that. You do have to say it with enough specifics so the public can see that it's a legitimate reason. So you've got, and by the way, one common thing, not in Torrington, is for an agenda to simply say, to go back to that first bullet, which was discussion of performance, evaluation, et cetera. If you simply put personnel, not enough. It does not satisfy the requirement. Nobody has to say, well, that's ever happened in Torrington. But that's not enough. That's too general. You need to be more specific. So, for example, if you're going to talk about, let's assume it's next June, June of 2014, and you're going to talk about the superintendent's performance evaluation. Essentially, that's what you're going to put on the agenda, discussion regarding evaluation of superintendent's performance. Suppose you're going to talk about, suppose there's a very sensitive teacher leave request. There's a teacher with some very serious personal matter, and he or she's requested a year off because they need to deal with a very urgent personal matter, and that's going to come before the board. But I'm just assuming, for the sake of argument, that it comes before the board. You could discuss that in executive session, subject to that teacher's right to have it be open, and you would say something like, on the agenda, discussion regarding teachers' request for leave of absence, something like that. You can't just put personnel. That's the FOI Commission's rule, that that's too general. So just be careful about that.
That's an interesting topic, which is, say for example, we look at the teacher attendance records. Not their records, but we monthly chart teachers, how many are present and absent every month. And then we say, well, gee, why is the we see this percentage 60, and then the business manager, superintendent said, well, that's because we have 5 teachers on leave for maternity leave. Now we want to discuss that more in detail. Are we? This is just kind of something that might get close to the topic I'm talking about. Are we getting close to actually being accused of discussing a specific teacher when there's there's only 2 teachers in the district and now we want to have a broad-based discussion of maternity leave? Are we now somehow, can it be alleged that we're specifically evaluating those 2 teachers who are?
Potentially, yeah, potentially. And again, I would just, you gotta be careful with, with any maternity leave is an example where clearly you want to be careful that there can be a retaliation kind of claim. You got to just be careful about those discussions generally, I would say. You can certainly talk about aggregate leave information, and I don't know whether leave requests come to you or not.
But I'm saying the aggregate is 2 people.
Yeah.
So, if it was 100, maybe, it seems like the more you can narrow down what could, should, or would be able to be discussed by the board as general concerns or budget or whatever. It seems like if you start narrowing it down to only apply to just one person.
I agree. Then you're going to be, getting close into the evaluation category for that one person. Yes. Which is why you're better off having the broader.
The broader discussion is that topic, except it narrows down to just one person.
But I think
it
you're better
could
off.
be.
Yeah.
Right.
I think you're better off having a broader conversation, or keeping it that way, if you can.
Next, another question
Sure.
on expulsion.
Sure.
So, the board has the right to protect the student records.
Has an
But-
obligation to,
Obligation,
yeah,
but it's
exactly.
not the board's obligation to protect the student's identity.
It is the board's obligation to protect
So,
student identity.
how do you do that when the expulsion hearings are public and the students are attending the expulsion hearing with their parents?
The meeting is public.
Right.
The board has the right and should go to executive session for every expulsion hearing, because that's going to clearly be a conversation about individual student matters and records. So the hearing itself won't be conducted in public, the hearing will be conducted in executive session. Now, you're right, when the board goes into the, opens up the meeting and then makes a motion, that's all in public session. And I know we've had situations here where we have attempted, I believe, to provide for and to protect the confidentiality of students. And I've addressed this in other districts where if there's a highly sensitive or highly political or highly public case, we sometimes have the parent and the student, for example, not be there during the public portions of the meeting. The part where the hearing is the meeting's gonna be convened. The parent may be somewhere else in the building, or in some cases, the board can actually go conduct, you open the meeting in here, and the hearing's gonna actually be in a different room where the family is already waiting. And so that is a way to protect the confidentiality of that student. But no, it is our obligation to do everything that we reasonably can to protect that student's confidentiality.
So shouldn't we do that for all expulsion hearings then? Shouldn't we protect the identity of all?
Well, I would say in 95% or whatever, I haven't studied it, but in most expulsion hearings, it's not an issue because no one else is there except the family and the student. If there are other people present, any people present, then yes, that would be a concern, and there may be a need to do that. Because obviously, if I'm a student up for expulsion, and I walk into the room and there are people sitting there, clearly I've been identified as the student who's going to be, or is up for expulsion, without a doubt about that. So yes, we should protect, to the extent that we can, the confidentiality of that student. That's why we, for example, in the motions at the end of the hearing, we never use the student's name, we never use anything that identifies that student. We use student O or student A or something like that.
Just a question, since I do the agendas and posting for the expulsion hearings. What exactly is a special Board of Ed meeting? Now, if I just put special Board of Ed meeting, then you've got the public that are coming because they have no idea that it's an expulsion hearing.
You would need to put, that wouldn't be sufficient. If you just
Right.
put special Board of Ed meeting, that's
Right.
not sufficient.
So-
You would need to put, most boards put expulsion hearing
Right.
or hearings, student discipline hearing, something like that.
That's what I do.
Yeah.
But then that also makes people want to come. So there's really no way of avoiding it. So any child that's up for an expulsion hearing, we should really sequester. And what if they're minors? And you've got the press here and you've got other,
The minor piece actually doesn't matter.
Doesn't
Under
matter,
Federal
okay.
law, is anyone
Okay.
who's a student, if they're 19 or
Okay.
whatever, they're a student, and then
Okay.
federal law applies to them. And so we have an obligation to protect their confidentiality, within reason. We can't disclose records. And to the extent that we can, if it's reasonably possible, I would suggest that we protect their confidentiality. Which could mean if you typically have other people present, any other person, other than administration and the family, then I would, or the people, it could be other people testifying like a police officer. I mean people outside the hearing. If you typically have other people present, then I think it probably does make sense to take steps to either have the board move into a different room or to have the student off somewhere else, and then be guided into the room, whatever's gonna happen to protect
and if
confidentiality.
you were to use 2 rooms,
Mhm.
you would have to have both recorded, is that correct? So you'd have to be,
Well, okay, 2 things. There's no requirement that you record public meetings of boards of education. You may do that, and others may do it. I mean, you may have cable access or whatever, that's certainly permissible. It's up to you to decide whether you want to record public meetings of your board, that's up to you. By the way, if you do that, you have to keep the tapes for 6 months, just as a side note, if you do that. But you don't have to. There's a separate statute that says whenever you have an expulsion hearing or a residency hearing or a transportation hearing, you have to have a tape recording. That's a function not of FOI, it's a function of those specific statutes. And you have to have either a course stenographer or a tape recording. Stenographer is expensive and you don't need to spend the money for that. So tape recording is fine.
And you'd want a full record, Deb, so you would want to
Absolutely.
record both portions of the
Both.
meeting. Yes.
Yeah, I think in that case, you would, because, for example, a motion, you'd want the motion to be very clear
Right.
and recorded. So in
so
that
what I
case-
was saying was, if you just go into one room, open the meeting, but you have the student and parent/guardian in the other room, do you have to be recording
I would,
the
yes.
opening of the meeting here?
Yes.
Yep.
In that
Okay.
case, I would absolutely do that, because that's part of the hearing. It's not the
Okay.
evidentiary part, but it's part of the hearing. And I would say that's especially true if the parent's not gonna be in the room, because you wanna be able to prove
Okay.
to them, this is actually what the board
Okay.
decided.
Thank
Right, because
you.
remember in expulsion hearings, where you can get tripped up is on the procedural technicalities.
Exactly.
So
Exactly.
we wanna follow that to the letter of the law,
Exactly.
because their really only remedy would be if you violated any of your procedural rights.
Right, and as you know, we've been running back and forth with
Right.
Old Yeller to room, so we'll take care of that. Okay, thank you.
I
Well,
mean, I
thank
think
you
hard,
for-
obviously
thank
in
you
this
for
building,
coming.
logistically, it's difficult in this building.
What's that?
Logistically,
Oh,
it's
yeah.
difficult.
Yeah.
Well, I just wanna thank you guys for coming, but we're out of time. And, if we get our August one up and running here for our board goals, we'll have you come back and.
Sure,
discuss
absolutely.
that.
Yeah, and I'm sorry we didn't get to go through everything, obviously, but it's good conversation and good dialogue about it, and I hope it was helpful to everybody. We enjoyed doing it, and I hope it was helpful, and obviously, if you think of questions afterward, without engaging in a meeting, you know, you can let us know, and we're happy to answer any follow-up questions anybody has, so. I hope it was
Can I
helpful.
get a motion for adjournment?
So moved. Second.
Chris, Carl, all those in favor? Opposed? Nope. Skipped everything else, lean right over.